A huge win for immigration advocates. A federal appeals court today said the United States must reopen the southern border for asylum seekers. The court called President Trump's declaration of an invasion at the U.S.-Mexico border illegal, saying the administration overstepped its authority. Trump introduced the proclamation blocking asylum seekers on the first day of his second term, citing public safety, health, and economic concerns. Since then, Border Patrol apprehensions have dropped to their lowest level in decades. Joining us now to break down what this ruling means moving forward is Assistant Professor of Law at Seattle University, Erin Carr. Erin, thanks for being with us tonight.
Hi, good evening, Joyce.
So in plain terms, just tell us, what did this federal appeals court ruling actually mean? What did they decide today?
Well, a lower court held and an appellate court affirmed today that the president's asylum ban at the southern border is illegal. And specifically, the court held that the president's executive order violates federal law, concluding that the president is not permitted to unilaterally adopt through executive action an alternative immigration system that replaces the immigration laws that Congress has constitutionally enacted.
So does it mean we'll see the southern border reopen immediately, or are there still some hurdles?
This ruling is not going to go into effect immediately, and it remains unclear when asylum processing at the U.S.-Mexico border may resume. Whether asylum seekers continue to be denied access to the asylum process may depend on whether the administration files an appeal in this case. The administration so far has yet to announce whether it intends to request that the case be reheard by the full appellate court or potentially appeals the decision directly to the Supreme Court. But considering that today's decision prevents the president from implementing one of his signature immigration policies, there's every reason to expect that the administration will likely appeal the decision.
So for people who are seeking asylum right now, what does it realistically change for them on the ground?
Well, today's ruling is important in that it reaffirms that individuals fleeing persecution are legally entitled to apply for asylum under U.S. law. But whether today's decision restores the rights that asylum seekers have been denied for well over a year will depend on how precisely this case proceeds. Functionally, little is likely to immediately change for asylum seekers at the southern border. Today's decision is, in fact, not the first time that a court has concluded that the president's asylum ban is unlawful. A lower court determined last summer that the president's executive order was illegal, and yet people have continued to be prevented from applying for asylum while this case has advanced through the courts. And it is likely that this case is not yet over, and it may very well reach the Supreme Court.
Also this week, the Justice Department announced that it is targeting hundreds of foreign-born Americans in an effort to strip them of their citizenship. So what does this mean for naturalized Americans, and how unusual is this?
The announcement this week that the Department of Justice would be reallocating resources to pursue a record number of denaturalization cases is a departure from how the government has treated naturalized citizens and will further contribute to an already legally precarious environment that immigrants in this country must navigate under the current administration. It is highly unusual and, in fact, quite rare for the government to petition a court to revoke a person's citizenship status. In the roughly 30-year period preceding the first Trump administration, the government filed an average of 11 denaturalization cases each year. By comparison, this week alone, the administration announced that it would potentially pursue denaturalization cases against 384 foreign-born Americans. And the administration has clearly signaled that they intend for this to be the beginning of a mass denaturalization campaign by the government.
So what legal protections do naturalized citizens have, and how high does the bar need to be for the government to strip someone of their citizenship?
Well, qualifying for U.S. citizenship is a lengthy and onerous process that involves extensive vetting by the government and that is intended to confer a stable, permanent legal status. For that reason, it is extraordinary for the government to later seek to rescind a person's citizenship status, which is also a resource-intensive and time-consuming process for the government. Once a person has satisfied the legal requirements for naturalization, generally their U.S. citizenship may only be revoked if it's determined that it was fraudulently obtained or if they commit a certain type of serious crime.
Well, it's something we're going to follow really closely because, as you said, it appears that this might just be the beginning of their efforts to do that. Erin Carr from Seattle University, thank you so much for your time once again on this Friday.
Thank you very much, Joyce.
Thanks.